welcome to the Bar Council seminar on handling ethical dilemmas. My name's Susan Grocott, KC. I'm a family specialist and I'm one of the vice chairs of the Ethics Committee. Your panel tonight, handling specific scenarios arising in civil cases, criminal cases, and family cases, are in that order: Matthew Morrison, who's been an Ethics Committee member since February 2021, and he has a broad commercial chancery practice with particular emphasis on civil fraud, company and partnership, and insolvency litigation. Martha Gray is a family specialist and a member of the Ethics Committee since 2019. She does a broad range of family proceedings, from abduction, forced marriage and placement of children abroad, to domestic cases in relation to children. And lastly, but certainly not least, is Lachlan Stewart. We're very pleased that he's joining you tonight. He's the Young Bar Committee's vice chair, and his experience of practice is almost exclusively COVID-19 related, something that most of you will have experienced as students or junior barristers. Lachlan's going to be dealing with the criminal ethical dilemmas, but also telling you a little bit about the Bar Council Ethics Enquiry Service and its value to you as young practitioners. We're conscious that we also have students joining this seminar this evening, and I hope that you've all had an opportunity to consider both the BSB handbook, BSB code guidance, and had an opportunity to look at the Bar Council's Ethics and Practice Hub. I'll just explain a little bit about how documents are considered and then published. They're not Bar Standards Board approved documents, that much you do need to know, because the Bar Standards Board doesn't publish guidance, which is why the Bar Council does. The Bar Council has an awful lot of committees made up obviously of barristers, both employed and self-employed, and a lot of the guidance originates from committees outside the Ethics Committee, but then is also considered by the Ethics Committee for approval if it has any ethical queries. In addition to that, the Ethics Committee itself publishes specific guidance on what are frequently asked questions. And the reason for that is simple, in that the guidance documents should provide the ready answer to most queries. We're grateful to everybody who sent in questions in advance. What's going to happen to those questions is that some of them will be incorporated within the answers to the ethical dilemmas posed, but also a great number of those questions can be answered by looking at the documents on the Ethics and Practice Hub. Give you one example of how those documents come into being. The IT panel, which reports to the Legal Services Committee, has recently published guidance on generative AI for the bar. That was published on the 30th of January of this year. I'm presuming that most of you will find that document extremely helpful. If I can just say that when I went to school, it was children who were not academically considered valuable who were sent to computer studies. And when I went to university, I would be just given a list of cases, textbooks, and articles and an essay title. The bar has changed immeasurably in those years, and part and parcel of that is the use of new technologies. All of you will have only ever been educated using technology, and we hope within that guidance you will be given information about how to use emerging technologies in a safe way, and it points out some of the pitfalls. Well, that's enough for me. I'm going to turn to Matthew. He's going to be dealing with the first 4 ethical dilemmas on your papers. We don't intend to read the questions out. So, Matthew.
Thanks, Susan. Just a couple of further preliminaries. First, you can, I think, submit questions or observations as we go along in the chat to make this a little more interactive than us staring at screens, not knowing if anyone's still there. So if you want to chip in, do, and that will be monitored, and we will try and pick out some of those ongoing live queries as we go along. The second is that we're going to be talking about the code and the handbook quite a lot. We're working on the assumption everybody knows what that is, and that within that there are core duties, rules, outcomes, and guidance. And I just thought it might be helpful at the very beginning to refresh anyone who's forgotten about those things, about what those all are. So there are 10 mandatory core duties, defining the core elements of professional conduct. Then there are the outcomes, explaining the reasons for the regulatory scheme and what it's trying to achieve. You then have the mandatory rules, breach of which can result in disciplinary action, and then guidance, which assists in the interpretation of the rules, but breach of which is not itself something that can be the subject of regulatory action. But if you decide not to follow the guidance, you'll have to show how you comply with the rule in your own way. So that's just a very high level view of what the scheme is that we're talking about. In terms of scenario 1, in a nutshell, this is the situation that occurs where there is a desire to preserve a relationship with a cherished client, either your own cherished client or a cherished client of Chambers, and there's a strong temptation to not act in a way that that client would be unhappy with. Now, the desire to preserve a relationship is something that people may think is important. Obviously, what you have to be guided by is the code. And just to get the ball rolling on this scenario, which I hope you've all had a chance to read, having regard to the duties in the handbook, including duties of confidence, duties to avoid conflict, and all that good stuff, we thought it might be good to throw up a poll question, and before we tell you the answer, see what you, the audience, think the answer to this one is. So you'll see on your screens a poll come up, which has the question, can you decline to take the case? And your answers are yes, no, or don't know. So if everybody could vote now, and I just noticed that the hosts and panelists can't vote, so we will wait for you to vote and see what you say. I don't know when we know when the answers come. Ah, there we go. Interesting. So 13% don't know. Perfect, respectable answer. Majority says no, and a sizable minority say yes. Thank you for your votes. As is often the case with ethical scenarios, views can differ on what the answer is, and what one has to do is to work through the code and the particular scenario and ask the right questions and consider the right things. So on this one, the starting point is really the rules of conduct concerning conflicts of interest and the use of confidential information. And instruction should only be refused where those principles are properly engaged. Now, Rule C21.2 says you must not accept instructions where there's a conflict of interest between your personal interests and the interests of the prospective client. But the relatively firm view of the committee, I would say, is your desire to receive future instructions from a particular client, or the fact you've previously acted for that client in the past, is not a sufficient reason to give rise to a conflict of interest justifying a refusal of instruction. Rule 21.3 then says you must not accept instructions where there's a conflict of interest or a real risk of conflict between the prospective client and one or more of your former or existing clients in respect of the particular matter, unless they all consent. But the key thing here is it must be in respect of that particular matter. The fact that you've acted for this particular client in respect of different claims will not be enough. That doesn't relate to the particular matter. There's also an interesting point on Rule 21.3 as it's expressed in the code, because read literally, it overstates what the ongoing duty of loyalty is. In particular, it's well established that in situations of other fiduciary relationships, such as agency or company directors, a duty of loyalty would generally come to an end at the same time as the relationship ends. And the highest authority for that remains the Prince Jeffrey case in 1999. Therefore, a conflict of interest between a former client for whom you no longer act and a prospective client, even in respect to the particular matter, would not, under the general law, automatically preclude you from acting for the prospective client, subject to considerations of confidentiality. And if you look at GC 69, so the guidance on the rules in 21, they specifically say that it's intended to reflect the law on conflicts of interest and confidentiality. So when you read it in that way, a strong argument could be made that the conflict rule only really applies where the duty of loyalty to the former client still subsists for some reason, despite the instructions coming to an end. And that's quite hard to envisage what that would be. A case in which the relationship was held to be ongoing was a case called Al-Subaihi and Al-Sanir in 2021, where it was held that the solicitor might still owe a duty of loyalty if they had somehow acquired a personal ascendancy over a client. Quite what that means and how that would arise is fairly unclear, but generally speaking, if your retainer's over, so is the duty of loyalty. What then of confidential information? Well, Rule C21.4 says you must not accept and therefore can return instructions where there is a real risk that information confidential to another former or existing client or any other person to whom you owe duties of confidence may be relevant to the matter, such that if you were obliged to maintain that confidence, you could not act in the best interests of the prospective client unless you get the informed consent of the former client to disclose that information. So basically, you've got to ask yourself, what information do I have from the former client, which I would need to disclose to the prospective client? And that's really the rule that gives rise to difficulties in this area. And as Susan said, the scenarios we're discussing are all based on calls to the ethics line. And this is one that comes in relatively frequently, where a barrister will have knowledge of a previous client's business and in the context of insurance in particular, settlement parameters and their general approach to life, and want to know, well, given that I know that, can I now act for this new client? Now, in my view, you need to look very carefully at the rule. The risk must be real, and the focus of the inquiry is whether you could act in the best interest of the prospective client, so the person you're going to act for, while retaining the confidentiality of the former client. Now, it might be, and this may be what those who voted yes were thinking of, that you act for a small insurer and you know the ins and outs of each department and the tolerances for risk and the settlement values that have been applied in the past. But it's unlikely that's commonly going to be the case. The fact you know an insurer has settled one or two vaguely similar cases on which you've been instructed, where you need to keep that particular information confidential, is unlikely to affect your ability properly to represent the interests of the new client. Ultimately, you've got to look at this on a case-by-case basis rather than apply a blanket rule. So you certainly can't say, I do not act against an ex-insurer on any matter, or even worse, I don't act for any insured against any insurer in a particular sector because of the cab rank rule, which is a sacrosanct principle of the Code of Conduct. I won't go into detail on this, but it's worth drawing attention to the Ethics Hub guidance on retainers and non-standard work arrangements and how they work with the code. The guidance is very clear that what a so-called general retainer, to stop you acting against a particular client in any matter, is contrary to the cab rank rule and prohibited. The same view is taken of a special retainer, debarring you from accepting a brief from any other party in a particular case, unless, of course, you are instructed on a case, in which case you can't obviously act for the other side. Those are to be distinguished from booking fees, which is effectively where you just agree to charge a non-refundable fee, such as a brief fee, for keeping yourselves free to undertake a particular piece of work, so long as the fee is a genuine pre-estimate of the amount of work you're going to do. You can also charge a fee for blocking out your diary for a defined period of time that's genuinely needed for professional work, but you can't charge a fee for simply agreeing not to act against a particular client. Nice work if you can get it in any event. I'm not sure how many people that applies to. I've certainly never been offered one. But if you are, you can't take it. So that's really my tuppence worth on the code implications of scenario one. And so on the face of what we're told in the scenario, unless you do have a really intricate knowledge of that insurer, it seems that those who answered no, which I'm pleased to say was the majority, are right, in my view, on that one. And you wouldn't be able to say no in this particular case. Now, the reason scenario two follows straight on from scenario one is it's a related question, which effectively involves applying the principles that I've just been through. So having regard to the facts of scenario two, we'd like you, if you would, to have another vote, if we can throw the poll up for question two. And the question is, must you take the case, or can you refuse on the basis of a conflict of interest between your former client and your prospective one? You need to get some kind of hold music while this is going on. Oh, right. Much more finely balanced, this one. This time the yeses are in the minority, 38%. Oh no, 38% said you must take the case. Hang on, I'm not sure what the yes and no actually relates to in the question now. I'm guessing people have, well, it's pretty finely balanced anyway. Let's say it's evenly balanced either way, whichever anyone thought the question meant. In our view, this one's at the other end of the spectrum, really. You've previously advised a party with an adverse interest to your prospective client on the very policy which will ultimately fund any payment. So if we look back at 21.4 again, although the facts bearing on the possible avoidance of the policy may not have a bearing on the merits of the claim involving the architects, clearly you have some confidential information from the insurer from your previous instruction, which could well be highly relevant, not least the fact that there is insurance securely in place and the policy won't be avoided. At face value, it could also be argued that 21.3 is engaged because of the real risk of a conflict of interest between the prospective client and your former insurer client in respect of the particular matter. But as we've already discussed, under the general rule relating to general principles of law relating to conflicts of interest, it probably shouldn't restrict you. But I think my view of this one is that you're much, much closer to the 21.4 prohibition because of the likelihood that you'll possess confidential information. But again, you probably want to carefully consider whether the avoidance you've previously advised on is in fact likely to be material in the particular case. But certainly this is at the other end of the spectrum. So that was scenarios 1 and 2, really about conflicts in confidence. Scenario 3, you'll be pleased to know there's no poll for this one. It's just a scenario to discuss. Raising the situation that you may face where a client comes along with some very interesting looking documents and you don't really know where they've come from. And the question is, with these emails, should you continue reading them or stop reading and ask how they've been obtained? In my view, you stop reading, at least for the short term, while you try to establish whether or not those documents were obtained illegally. And in terms of illegality, it's worth remembering that doesn't just mean criminal acts. It also means acts that would be an actionable breach of a civil obligation or duty. So that would include breach of confidence, the tort of misuse of private information, offences under the Computer Misuse Act, the Data Protection Act, and obviously anything involving trespass to land or goods. There's also copyright to consider. So there's quite a lot to take into account in terms of what might have been breached in getting these emails. One thing to bear in mind if you have an international practice is if the information or the documents were gathered from abroad, you may actually need to obtain some advice on what was permissible or impermissible under the applicable foreign law. But if it appears to you that the documents were indeed obtained by legal means, there's one important immediate consequence. The documents will not be privileged. So they're not covered by the litigation privilege between you and your client because, as is well established from Dubai Aluminium and Alawi and other cases, there is no privilege in iniquity. You will therefore have to disclose them to the opposing parties in the ordinary way at the appropriate time. And if your client refuses to allow those to be disclosed, you're then in the territory of withdrawing from the case without disclosing the existence of the documents in accordance with the BSB handbook guidance at GC 13 on when you can withdraw. Unfortunately, that's not the end of the matter, because in the Immerman and Cengiz case, the Court of Appeal in 2010 considered that a party which obtained its opponent's documents by legal means should be stopped from obtaining any benefit from having done so, and should therefore not be able to retain until disclosure that material. In the Immerman case itself, the court made an order requiring all originals and copies to be handed back to the opponent, with a complete set being passed to the opposing solicitors to be kept by them unless otherwise ordered. And then those solicitors would be obliged, when disclosure came up in the proceedings, to disclose such of those as fell within the scope of disclosure. So you effectively have to get the whole lot back, and then you see what gets disclosed back to you. A particular problem for lawyers is that the lawyers themselves will be restrained from disseminating or making any use of the information obtained through reading the documents, which can put you in a very tight situation indeed. So if you are in this situation, your immediate professional duty is to consider what you need to do. First and foremost, you should read the Immerman decision in detail and then make up your mind what that decision requires of your client. And that's really a question of law, not professional ethics, but obviously you are the regulated professional who has to act appropriately. In circumstances where the offending material is that of an opponent, you should certainly advise your client to hand it all back at once, possibly obtain an undertaking from the opposing solicitors to hold one complete set to the order of the court, and those who've seen the information on your side, including your solicitors, should give an undertaking to the court not to disseminate or make any other use of the information pending a further order. If it's not as clear cut as that, you can apply to the court and ask the court to tell you what to do. Now, if you give that advice and the client refuses to act on it, the view of the committee on this particular issue is that you should withdraw from the case in light of the duties, particularly in Rule 21. If you read information that's evidently confidential to your opponent, you're going to end up owing duties of confidence to that opponent and maybe a defendant to proceedings to enforce that confidence. So it's going to compromise your integrity. It's going to put you in a very difficult conflict situation. You also need to consider the implications of misleading the court if you've read material that was illegally obtained. So effectively, this is a nasty situation to come about, but the most important thing to do is to conduct the appropriate investigation and take the appropriate action. You certainly shouldn't just read the documents and hope for the best. So that was all I was going to say on scenario 3, unless any of the other panel want to jump in. We haven't had much in the chat. So if no one's got anything else on that, I will crack on with scenario 4. Obviously, this arises on the facts from the recent attempts by environmental protesters to buy small numbers of shares in oil companies and then bring derivative action saying they're breaching their duties to have proper climate change plans and the like. Obviously generated quite a lot of media interest, but the scenario we're faced with here is how much you, the barrister, can jump on that media bandwagon, start writing and blogging, using your social media, getting awareness for your client's cause, and effectively becoming a public spokesperson for your client. And the question asked in the scenario is, should you agree to do any of that? Now, in earlier times, which many of you in the audience probably won't remember, but those on the panel may, we didn't have to worry about this because the Code of Conduct prohibited a barrister from expressing personal opinions to the media or making public statements on any anticipated or current proceedings in which the barrister was briefed, was expected to appear, or had appeared as an advocate. So you effectively stopped from saying anything to anyone about it, which was in some respects a much easier and possibly happier time. Unfortunately, that quite clearly breached Article 10 rights to freedom of expression, and as a result, barristers may now express personal opinions in the media or make a public statement in relation to such anticipated or current proceedings. But the ethical framework is not as permissive as the relaxation of the rule may apply, because the core duties still apply. You still have to act in the best interest of your client, core duty 2. You still have to act with honesty and integrity, core duty 3. Maintain independence, core duty 4. Keep things confidential, core duty 6. And not bring the administration of justice into disrepute, core duty 5. And then those are complemented by Rule 8, which spells out you must not do anything which could reasonably be seen by the public to undermine your honesty, integrity, and independence. Now, it's worth reading if you're ever asked to do these sorts of things, the guidance in GC 22, because it specifically discusses media comment and spells out what you should bear in mind, including the need to act responsibly, exercise your professional judgment, and have regard to the full range of professional duties. Now, for the more media shy amongst you, it may also be a relief to learn there is no professional obligation to express views to the media or to agree to do so. So that is at least helpful. But an implication of that is you're not insured if you do it, because it's not part of the legal services you're providing. So if you do it, you're out on your own if you end up getting sued as a result. In terms of the scenario posed by question 5, I think a good starting point is to bear in mind that an advocate's role is to represent the client and present the client's case, not to identify yourself with the client's cause or to act as a mouthpiece. Going too far in the direction of becoming the public spokesperson of your client risks jeopardizing your ability to comply or give the impression of compliance with your overriding duty to the court and your duties to act with integrity, independence, and not to discriminate. Obviously, you will also have to avoid disclosing information that's subject to privilege or is confidential, and that could make writing the article or sharing it on social media very difficult indeed. That's especially so if you're going to write pieces saying that my client's sure to win on appeal, and that overstates your honestly held views as to the prospects of success, which you obviously can't reveal because they're privileged. You also have to make sure you don't reveal any information that's not in the public domain or refer to documents that are subject to collateral use undertakings if they've been disclosed from the other side and not yet referred to in open court. Bear in mind also that any comments are free from the privilege in terms of liability for contempt, defamation, or malicious falsehood. I also think it's worth bearing in mind that cases can develop over time, and it may be something of a hostage to fortune to express a firm view as to the prospects of a case publicly before it's finally concluded. If subsequent information emerges and you then advise upon it in a privileged context, it's going to be quite hard for you to go back to your publicly expressed views and say, actually, I no longer subscribe to the view that this is a surefire winner, or such other views you may have expressed. Also, perhaps worse, but not really a breach of the code, but more why this is something to avoid, expressing confidence you have a surefire winner in the Court of Appeal and then losing may not fill prospective clients with confidence in your abilities as a barrister in any case. And added to all of that, there's a risk of bringing the profession into disrepute if you're regarded as rabble-rousing or trying to generate troll by media and undermining the independence and objectivity of the profession. All of that sounds pretty terrifying and a reason never to do this. And if that's your takeaway, it probably would do no harm. But in terms of how you might want to think about media comment, if it is something you want to do, it's always worth bearing in mind that a pre-written article gives you much greater control than ever agreeing to do a live interview. If you agree to do a live interview and you get put in a professional conduct problem, you may have to just say, I can't comment on that, which may not be in the best interest of your client or their public perception, because it will make it look like you're being evasive and that your client has no answer to that question. An alternative middle ground, if you did want to raise awareness of the case, either for your professional or socially motivated reasons, is to get a colleague in chambers to write a balanced piece on the case in question, and of course they'd be free of the constraints which would come from being counsel in the case. Finally, before I hand over to someone else, please be aware that the BSB has published specific social media guidance now. And in the context of that, it's worth bearing in mind that core duty 5, not diminishing trust and confidence, rule C8, not doing anything which would reasonably be seen by the public to undermine honesty, integrity, and independence, they apply to barristers at all times in your personal or your professional life. Now, this obviously has Article 10 implications for barristers because we all have rights to freedom of expression, rights to a private life, rights to freedom of thought, etc. And it's for that reason that the guidance helpfully makes clear that it's not necessarily the substance of the views you communicate, unless they're obviously discriminatory, dishonest, or similarly impermissible, but the manner in which you express yourself on social media. So intemperate language, anything that's harassing or bullying, is more likely to transgress. And a very important thing to be aware of that the guidance specifically flags is that liking or resharing posts is your own comment on that post. And therefore, if you think, oh, I'll just stick a thumbs up to this without reading it that carefully, and you don't state whether you disagree with something that's offensive in there, that may well end up putting you in breach and the subject of disciplinary action. So basically, be very cautious with all of these things. Do read that guidance and do think very carefully if you're ever asked to speak to the media about how you can best manage all of the risks I've outlined for you.
Thank you very much, Matthew. I've put in your chat a message to you all that you can send in ethical queries. We have behind the scenes, you can't see them, Sarah Richardson and Caitlin Lambu, both of whom, as well as their many other duties for the Bar Council, act as Bar Council ethic advisors. And as Lachlan's going to talk to you about that service in a minute, I won't say anything more. The only caveat is that unlike the helpline, any queries that come through on the chat button will not be confidential. So please bear that in mind if you are going to post. Lachlan, questions 5 to 7.
Thank you very much, Susan. Before I do that, should I deal with the ethical helpline? But firstly, my name is Lachlan Stewart. I'm the Vice Chair of the Young Bar Committee. You've heard from Susan that there's a number of committees as part of the Bar Council. Just so you know, the Young Bar Committee is very relevant to most of those on the line. It's barristers 0 to 7 years. We are there to represent your interests, dealing, for example, with how COVID has changed practice for young practitioners. And so we want to hear your concerns. If you have any, please direct them to the Young Bar Committee. And we also run really exciting initiatives such as exchanges, such as with the Anglo-Dutch exchange, which is with lawyers in Holland. But moving to the ethical inquiries service, the aim of it is to assist barristers interpreting the code of conduct. It's available to all barristers, pupils and their support staff, including clerks and practice managers. So what is it? It's a confidential telephone helpline. It's open 5 days a week from 9:15 a.m. to 5:15 p.m, as well as email inquiries. They respond as quickly as they can, and they aim to respond to emails within 4 days. But if the matter is urgent, you're best to call. The telephone queries are not recorded, and the details of the helpline are on the Bar Council website. How does it work? Well, an ethics advisor will listen to your issue, try and assist by identifying the core duties, the rules, the guidance, and signposting you to relevant Bar Council or BSB guidance, which often, if an issue has arisen at court, you may not have memorized all of the relevant rules and guidance that might apply to your situation. So it's a really helpful service to give you a steer as to what applies. If it's particularly tricky, then the advisor might consult another advisor or might escalate things to the ethics committee, who will call to assist you. And it's well used. 4,000 to 5,000 telephone calls a year and 600 to 700 email queries a year. But there are some limitations. It's not legal advice. If the call's escalated to an ethics committee member, you may not receive an immediate response. But this is because they're all practicing barristers and they may be in court, but they will call you back. And ultimately, barristers at all times are personally responsible for their professional conduct, ethics, and decisions. So whilst the Bar Council team will aim to assist you, you must reach your own conclusion on what your professional obligations are and the ethics that apply to your particular situation. There are some other limitations, and if you want to look at those further, they're detailed on the Bar Council's website. So what to do if an ethical difficulty arises in your practice? Firstly, look up the relevant core duties and rules in the BSP handbook. Check if the issue is addressed in the extensive guidance provided by the Ethics Committee and other Bar Council committees by checking the Ethics Hub. And may I say that most common queries have been addressed on that Ethics Hub in guides. The guides are, if you go to the Ethics Hub, then you know that that guide will have been recently up, that will be up to date. They're user friendly and they're absolutely worth checking when something comes up. Generally as well, it's always a good bet to try and discuss it with your peers and senior practitioners within your chambers or your place of practice. But then, if you still need assistance, then please get in touch with the Ethical Inquiry Service, and they will do their best to assist you. And really, another point to add is that your BRF fee that you pay every year, or I hope that you would consider paying, is what funds things like the Ethical Inquiries Helpline. So that's why it's so important to pay your BRF fee. I'm now going to move to the criminal scenarios. So the first scenario is effectively about if you have no instructions, could you withdraw, and how does remuneration impact your decision to withdraw and your involvement in a case? Now, the question is, are there grounds to return instructions? This is a poll question, so I'd invite the poll to be put up now, hopefully. Here we are. So, in respect of scenario 1, are there grounds to return instructions? Yes, no, I don't know. If you could all please answer that. Are there grounds to return your instructions? Yes, 46%. No, 40%, and 14%. I don't know. So it's reasonably finely balanced, and it's unsurprising that in most of these poll questions, the answers have been quite well balanced because, as I'm sure you're all aware, ethics questions sometimes are matters of, sometimes they do cause debate and they're not often straightforward. I'm going to work through this question, but if I give you my short answer, which is that in short, yes, there are grounds to withdraw due to no instructions, but it may well be in your client's interest to stay on, and that the remuneration in these circumstances is not a reason to withdraw. So if I now work through the scenario, firstly, the core duties. Well, the key one here is you must act in the best interests of each client. And that's also enshrined in Rule 15, that you must to provide a competent standard of work and service to each client. Where you have no instructions to put forward, it's unlikely that any decision to withdraw would be criticised, depending on how far the trial or hearing has proceeded. Any decision to withdraw from proceedings will engage Rule 26.8, which is effectively the circumstances where a barrister may withdraw. And this would fall into the category of there is some other substantial reason for doing so. If you were to withdraw, then you must comply with the guidance at 83. You should, where possible, and subject to your overriding duty to the court, ensure that your client is not adversely affected because there's not enough time to engage adequate legal assistance. But in this case, if you, for example, you're withdrawing mid-trial, the trial's up and running, you're read into the case, you've begun it, then clearly your client is going to be massively prejudiced should you withdraw from the case. But in this scenario, the barrister that replaces you is unlikely to be, your client's unlikely to be prejudiced because whoever replaces you doesn't have instructions either. When you return instructions, you must not return them unless you have your lay client's consent. Now, of course, you can't get your lay client's consent, but Rule 27 states that you have clearly explained to your professional client your reasons for withdrawal. So you need to contact your solicitor. You should record your decision in writing and the reasons for it. And you should provide this to your instructing solicitor. And as a practical point of view, always contact your instructing solicitor in circumstances like this, because not only are you going to be leaving your client in a difficult position, you are also going to be putting your solicitor in a difficult position at sourcing counsel at potentially late notice. And also, you've read this scenario, it's perhaps not the most attractive brief to be picking up. However, as part of your duty to the administration of justice and to your client, it might be, you may take the view that although there is no contribution that you can make to proceedings, it would be in your client's interest for you to remain to ensure that the hearing is conducted fairly and without error. And that may also be something that the court invited you to do. In regard to the issue of a low fee, dealing first with the rules, Rule 29, the cab rank rule. If you, as a self-employed barrister, if you're instructed, if you receive instructions, you're obliged to accept those instructions if they're appropriate, taking into account your experience, seniority, or field of practice, subject to the exceptions at Rule 30. And so unless there's any exceptions, you must accept the instructions. Rule 28.3 prohibits you from withholding your services on any ground relating to the source of any financial support which may properly be. So given that the prospective client in this case is legally aided, guidance at GC 88 makes clear that this includes refusing to act on the ground that the support, on the ground that the client is legally aided. Now, an exception to the cab rank rule is that, and contained in Rule 30.8, is that you've not been offered a proper fee. But in this case, you've accepted the brief. And so you've already accepted the brief. And although the one way that you may, if you're going to raise the issue of an acceptable fee, then that's something that needs to be done before you accept the brief, within a reasonable time of receiving those instructions. That's not been done in this case. And so the fact that the fee is perhaps not the best fee does not absolve you of the need to attend and represent your client. And more importantly, I haven't found any provision for allowing the fact that that there may be better work out there or potentially higher paying work. Again, that would not absolve you of the need to attend and represent your clients. And so, in short, because of the lack of instructions, you would have grounds to withdraw. It's unlikely to prejudice your client too much because whoever replaces your client is going to be in a similar position, but it may well be in your client's interest to stay on. And remuneration would not be a reason in this case. I'm going to move to the second scenario now. This is client history of drug misuse, turned up at court with dilated pupils, and he seems out of it, but he denies being under the influence of drugs. Again, I'll give you the short answer. In short, you can probably still take the instructions. It may or may not be in your client's interest to participate in the trial, and with your client's permission, you could inform the court. So if I start with a general rule in respect of, and again, in criminal practice, as in family, and sometimes other areas, it's not uncommon for a client to have substance misuse issues, or wider capacity issues. And the case of P 2008 has addressed this issue. And it states that the general rule is that once a legal advisor entertains a reasonable doubt about their client's capacity to give instructions or to give proper instructions, it is that advisor's professional duty to satisfy themselves that the client has or does not have capacity to give those instructions. So, core duty 2, you're under a duty to act in your client's best interests. If a client attends under the influence of drink or drugs, but you reasonably believe that they are capable of understanding advice, giving instructions, following, and if necessary, taking part in proceedings, then you may be able to continue. Or you should, if you were satisfied, then you can continue. However, Rule 15, you're under an obligation, you're under a duty to advise the client as to the client's best interests. So in this case, look at it practically. If you think your client has capacity to continue, but then you must think, well, but is it in his interests? And the answers to that will often be no. And so your duty would normally lead you, or your duties would lead you to seek an adjournment to the case. But ultimately, if the client has capacity, then you follow the client's instructions, which may be to proceed. And that's even if those instructions appear unwise. Now, the matter of judgment in respect of drink and drugs is something that counsel could make an assessment of. However, if it's anything wider than that, such as psychiatric illness, then that's not something that it would be expected that counsel would be able to judge without some form of medical evidence or some extraneous evidence, because ultimately we are lawyers, we are not doctors. Another core duty that's important in this case is core duty 6, which is that you must keep the affairs of each client confidential. So, could you inform the court? The answer is, well, it depends, because if your client says, no, I do not want the court to know, I will not permit you to inform the court, then of course you are there to follow your client's instructions and you are bound to keep his affairs confidential. If you deem him not fit to give instructions and to participate, and you're given permission to seek an adjournment, and that adjournment's not granted, then you may need to consider flagging, may need to consider withdrawing on the basis that you effectively have no instructions. You cannot, if you form the view that the client doesn't have capacity to give you instructions, then you can't proceed with the trial as normal, given that you're not receiving proper instructions. Again, though, similar to the previous scenario, you may wish to consider whether you stay on, but in a limited role, to ensure that the hearing is proper and fair. And as ever, fully note your decision-making and your client's instructions. And that's simply in any issue where ethical, or any problem where ethical issues arise, it cannot be understated the importance of taking a full and contemporaneous note of your decision-making. Moving on to the third scenario. There is a poll question for this. This is a scenario where effectively client has said one thing in interview and accepted parts of the Crown's case, has told you something in conference, and then has told you something different, but that what he's told you distances himself further from the prosecution case. And so I'd invite the poll question to be brought up. Should counsel withdraw from the case and return the client's instructions? Yes, no, I don't know. I invite you to vote. So yes, 22%, no, 61%, 17%, I don't know. The short answer, you may have to withdraw from the case depending on how things develop, and that the judge has no power to compel you, but you could potentially stay on to provide limited assistance to the court. Of course, core duties 1 and 2 are engaged in this scenario, but also core duty 3, you must act with honesty and integrity. Core duty 5, you must not behave in any way which is likely to diminish the trust and confidence placed in you and the profession. And 6, you must keep the affairs of each client confidential. There's a number of rules at play in this scenario, and if I just flag those before working it through. Rule 6, you must not mislead the court by making submissions, representations, or other statements, or asking questions which you know or are instructed are untrue or misleading. You're also under Rule 5. Your duty to the court does not require you to act in breach of your duty to keep the affairs of each client confidential. Rule 9, you must act with honesty and integrity, which includes you must not knowingly or recklessly attempt to mislead or attempt to mislead anyone. Rule 9.3 prohibits counsel from encouraging a witness to give evidence which is misleading or untruthful. And however, guidance point 6 or guidance GC 6, your duty to the court does not prevent you from putting forward your client's case simply because you do not believe the facts are as your client states them to be. As long as any positive case you put forward accords with your instructions and you do not mislead the court. Of course, as you're all aware, when you are acting as an advocate, you are there to present your client's case, and it is not for you to decide whether your client's case is to be believed. This scenario is closely modelled on an issue that arose in the case of R and Daniels 2021. Well, not closely modelled, but the case of R and Daniels, which has been dealt with very helpfully in some guidance on the Ethics Hub, explains why this matters and how counsel might navigate this scenario, because it's not uncommon for clients' instructions to be more fluid than we would like. Effectively, any change in clients' instructions needs to be carefully analysed in order to see whether or not it brings your client's case closer to the prosecution's case or further away. So, using an example, if your client's defence is alibi, and he now accepts that he was present at the scene of the crime, but he's saying it's self-defense. Now, that is a material depart from his previous instructions, but you would probably not be professionally embarrassed because your client is not resiling from a part of the prosecution case that he's previously accepted. However, if, for example, pardon me, but that may not always that may not always be the case, because if the defense, for example, is self-defense, but then your client now says, I wasn't present at the scene, and you're instructed to put evidence of an alibi before the court, then that may be something that leads you to be professionally embarrassed and for you to withdraw, because previously your client's accepted presence, a key part of the prosecution case, and you are now being instructed to resile from that which your client has previously accepted. Some things to consider is the stage at which the change of instructions occurs. Have you publicly associated the defendant with an acceptance as part of the prosecution case? For example, is it in your defense case statement or in agreed facts? Or, for example, have you cross-examined a witness about how your client wasn't there? If it's not something that you've previously publicly attached your client's case to, then this may not lead to professional embarrassment. But if you have publicly cross-examined a witness on the fact that your client wasn't there, and now you're instructed to put forward a case that says that your client was there, then that could lead you to being professionally embarrassed. I appreciate that was quite long, but that sets the background to how to approach this problem. So, firstly, get your client to sign these new instructions and also to sign what his old instructions were, so you're very clear what you're working with. In this case, his interview is a partial admission of the Crown's case. His first comment to you is consistent with what is broadly consistent with what he said in his interview. But his second comment takes his case further away from the Crown's case, and he no longer accepts a key part of the case, which he'd previously accepted, which is, i.e., I took part in some violence. But the key word in this scenario is misunderstood. It's stated that you've misunderstood his instructions. You must get to the bottom of what this means. Generally, ethically, if there is a change in your client's instructions that puts him further away from the prosecution case, and so you're entering the potential to be professionally embarrassed, then it's what could potentially save the situation is your client's explanation as to why he has changed his account, and that explanation is maybe something that satisfies you, that you can continue and that you wouldn't be misleading the courts. And so that's what you need to get to the bottom of in this scenario. If you aren't provided with an explanation, then that may lead you towards withdrawing. Of course, if you did withdraw, the usual considerations for withdrawing would apply, which I've already outlined in respect of another scenario. In terms of withdrawing, then when you inform the court, you must not breach the client's confidentiality. Again, make accurate, full, and contemporaneously timed notes. But in a situation like this, one would expect you to take some time and to simply say, you may wish to say to the judge or your opponent, I know this was a question that was raised in the emails, say to your judge or your opponent, an ethical matter has arisen. I need some time to resolve that. And certainly my experience, and I imagine the experience of everyone else on this panel, is that when you raise something like that, both judges and opponents are well aware of that you may be in professional difficulties and will give you the time that you need. And so in terms of as a rule of law, and when you take that time, please do contact a more senior member of your chambers or the ethics helpline. The judge cannot force you to stay on as a rule of law, but you could stay on to provide limited assistance to the court and the client. I appreciate that's taken some time. Those are my scenarios. I'll pass back to Susan.
Thank you very much, Lachlan. On that last point about allowing time, of course, everybody's reminded about what you need to do if judicial bullying appears on the horizon. Check out with the Bar Council website in respect of that. I'm going to hand over to Martha. We've become aware during this that not everybody has got the actual handouts that were sent. Can we just apologise to everybody? And I suspect that the consistent numbers of I don't know relate to people who didn't actually have the questions in front of them. And that's why, and that shows a good caution on the part of prospective members of the bar and members of the bar that you chose that option. Because we're running out of time, what's going to happen is Martha will deal with just questions 8 and 10. The reason for that is these are very short questions, and so she's going to be able to read them out before then dealing with the potential answers to the questions. 9 is a longer one. If anybody gets terribly disappointed about 9, let us know, and I'm pretty sure we can send you what would have been the answer directly. So over to you, Martha.
Thank you very much, Susan. Hello, everybody. I'm going to, as Susan said, deal with some of the family questions. I appreciate not all of you will be family practitioners here today, but I hope that you'll find that these are useful scenarios because you'll probably find that they're of general application. So we'll start with scenario 8, which is a barrister who's representing a mother in care proceedings. The mother's lifestyle has been chaotic and she has had substance abuse issues. She told the barrister that she'd been clean for 6 months, and this is noted in her witness statement. However, in a conference, she took a phone call that sounded a lot like she was discussing the purchase of drugs. And we're going to start with our question for a poll. Will the barrister be misleading the court if she does not correct the position? So over to you all. Interesting. So we've got No's in the majority with 61%. Yeses next with 30%, and 9% on the I don't knows. And in an unusual move for a member of the ethics committee, I think I'm going to actually side with the I don't knows for this one, and I'm going to explain why. I should say that one of the reasons why this is such a tricky, you can see why this is such a tricky issue, because we had a very similar question that somebody posted in the chat just a few minutes ago, posing a similar, not dissimilar question about seeing a witness kissing a partner or an ex-partner in proceedings in which dishonesty about relationship was the key issue. I hope that this scenario is going to be particularly useful to the person who raised that question. The reason I say that I don't know is this, that what we're told in the scenario is that the call sounded a lot like the client was discussing the purchase of drugs. But we don't know whether that is something that this barrister has inferred because the mother was talking in hushed tones and acting a bit shady, or whether they actually heard the mother engaged in the purchase of drugs. If it was the former, then you're not required to do anything. You have a suspicion. Your duty is to act in the best interest of your client, core duty 2, to provide a competent standard of work and service to your clients, core duty 7, and to keep the affairs of your client confidential, core duty 6. If, however, you are clear that you heard your client purchasing drugs on the telephone in contradiction of your client's instructions to you and your client's evidence to the court, then you do have a problem. Your duty to act in the best interest of your client is obviously subject to your duty to the court, and your duty to the court does not require you to act in breach of the duty to keep the affairs of each client confidential. You can tell I've just come from work, and that's rule C5. But you must not knowingly or recklessly mislead or attempt to mislead the court. And clearly, in a position where you have heard specifically a conversation where your client is purchasing drugs, you will be misleading the court if you do not correct the position. Now, we've gone, Lachlan just now has gone through in some detail the steps that you need to take if you're in that position, so I won't go through it exhaustively. But the first step is obviously to inform the client of what you've heard, to request your client's authorization to inform the parties of the court. If the mother wishes to withhold that information, I would suggest that you would advise her firstly of the importance of disclosing this relevant information, and advise her that in most cases this is the sort of information that's likely to emerge in any event, in cross-examination or further investigation within the proceedings. So perhaps if there's going to be some hair strand testing or something like that, and also that it's usually less damaging for a client's case to be honest and open with the court at the outset. And I say that because it's, practically speaking, you want to take steps to have a conversation with your client to when you're speaking to them about whether or not they will agree to your authorising you to inform the parties in the court of what you have heard. It is not simply a question of saying, I've heard this, do you agree? That's a discussion that you're having, and those are some of the factors that might come into that discussion. If the client doesn't consent to disclosure, then you're obliged to withdraw from the case and to return your instructions, because, as you've heard from others, you mustn't continue to act for a client knowing that information exists which ought to have been disclosed and has not been, because your client has refused to permit its disclosure. And you've already heard from Lachlan in some detail that you must obtain your client's consent or explain to your professional client the reasons for doing so, or return instructions to another person. So I trust that you've got all of that very clearly in your mind, and the steps which follow. So that is, in at some speed, my answer to scenario 8, which really, and really, I don't know, comes down to what precisely have you heard, and needing to be very clear in your mind about that before you take the steps which follow. As always, it very much depends on the particular circumstances of the case. So let's turn to scenario 10 then, which I'm going to read out for those of you who don't have the handout, or who don't have it clearly in their mind. Scenario 10 is: my cousin wants me to represent him in his messy divorce. I see him occasionally at family get-togethers, but am not that close to him. Can I represent him on a pro bono basis without a solicitor? I am not public access qualified. Well, we can answer that one fairly quickly. If you're not public access qualified, then you can't represent your cousin, because you would need to be direct access qualified to represent him. You would be able, hypothetically, to represent him with the assistance of a solicitor, or to represent him if you were public access qualified. But in terms of your ethical duties, you would have to consider core duty 4, and whether your connection with the cousin is close enough that you might find it difficult to maintain your professional independence. And I think this is perhaps an issue that does crop up for family lawyers more than it does for some others, and perhaps especially as you get older and find that you're being asked to help out with friends and family members' divorces and problems with their children more often, which does seem to happen. Things to bear in mind: the more serious the matter, the more likely it is that you might find it difficult to advise as independently as someone who is not connected with the client. So if you also know the ex-partner, you'll need to consider whether your knowledge of that ex-partner places you in a position of conflict, such that you can't provide independent advice or representation to your cousin. Core duty 6 also requires you to maintain your cousin's confidentiality, and you'll want to think very carefully about whether that is compatible with your professional duties and your friendship. Susan, I've finished with 10 minutes to go, those two sections. So I don't know whether we want to use the extra time by whizzing through scenario 9, or using it to answer some questions from the attendees, and I'm entirely in your hands.
Well, Martha, as you were speaking, both question 9 and your responses to question 9 have been posted on the chat. There was a query on the question and answer as to could we find out, please, what the answer was to question 9, Well, anybody who's now read the chat will know the kinds of matters you need to take into account in that scenario. So I'm not sure we need to do question 9. I think if we do an additional question, I might choose the additional civil question of Matthew, simply because that relates to all 3 disciplines. Are you okay with that, Matthew?
Absolutely. I think we've also got a poll on this one, just to finish with a bang. So yeah, what we need to do is I'll tell you what, well, I can read this scenario out and then maybe it can be posted in the chat. So the question is this: you have been conducting a CNC remotely using Teams. Your client subsequently tells you that, contrary to the court's instructions, he has made a recording of the hearing on his laptop, has transcribed what was said at the hearing, and suggests you use his transcript to make follow-up submissions. The question, and this question is admirably clear about whether it's yes, no, or don't know, is should you use the transcript? So let's see what the hive mind of our delegates thinks. Okay, well, we've got a pretty clear answer there. 88% of no's, 4% yes, 7% don't know. Well, I think that the overwhelming majority makes clear the answer to this scenario, which is clearly right. But actually, there's a host of other ethical considerations which flow. So if we've got 5 minutes, I'll just walk through some of them. And if anyone on the panel wants to chip in with their thoughts as well, that would be great. So obviously, recordings and using mobile phones is a bit of a hot topic because things are online now. It's much harder to monitor what people are doing. And people tend to use mobile devices to record and curate their entire lives now, and are not used to fora in which you can't record things or use phones in that way. But despite the marching on of time and the evolution of society, it is still a contempt of court and a criminal offence to record court proceedings, including remote hearings. And as I'm sure you've all seen, the courts go to great lengths to tell you that, both in writing, and the usher normally gives a formal warning, and often the judge gives the warning as well. Nevertheless, recordings are made. And the bottom line is that it shouldn't have been made. Using it for submissions would aggravate the offence and involve using the product of a criminal offence. And it's therefore a relief to see that 88% of the audience said don't use it. The more troublesome question is, do you have to shop your client to the court? And the answer to this is, as with many ethical questions, it depends. There is no duty to report historic crimes or contempt, and in general, the duty of confidentiality would stop you from doing that. But that duty is expressly subject to the overriding duty to the court and the administration of justice under Core Duty 1. If you can satisfy yourself there is no ongoing risk to the administration of justice, disclosure is likely to not be required and indeed not to be permitted. But if there is such a risk, you will have to report the matter to the court with the client's permission. And if the client doesn't give you that permission, it's likely that this is another withdrawal scenario. Let's just look at how that works in practice. If your client says to you, look, I understand I shouldn't have done it, I'm sorry, I've deleted it, it will never see the light of day again, it doesn't exist, that's probably going to be the end of the matter. The only caveat to that is if there's a chance that the question whether or not a recording was made will arise in the future. For example, if the other side have said, was your client recording that hearing? You might have to be very careful about misleading the court if that question is asked. Because you've either got to mislead the court or shop your client. So in those circumstances, you're back to having to ask your client for permission to disclose the recording and withdraw if you consider that remaining silent on the matter will interfere with the administration of justice or your duties to the court. In a more extreme case, you may have a client who's unrepentant and says they're intending to publish a recording or a transcript because the whole hearing was such a travesty of justice. Now that is a prospective crime, potentially interfering with the administration of justice, and disclosure with the client's permission or withdrawal is almost certainly the outcome you're going to arrive at there. Now, one final point, which may not arise certainly in civil practice very often, but is perhaps more common in other cases, is where disclosure needs to be made even if you've withdrawn from the case because of a need to protect others. So a possible example of that would be the potential publication of material involving children or sexual abuse, where the risk of harm to others requires you to make known that that recording has been made. But in general, and certainly in civil, the potential outcomes I've already been through are probably the likely ones. But if anyone's got any more perspective from the panel, then do jump in.
Thank you, everyone. We've got 4 minutes left. Thank you for that, Matthew. For the answers to the latter queries posed, including when might you have to disclose, then please refer to the Practice Guidance and Ethics Hub, which will talk you through what happens when there is a risk of significant harm to others arising from the information you have received from your client. Last chance for question and answers. I think we've got one just coming up. Nope, I don't think we have any.
There's a couple of unanswered ones. How do you withdraw from a case without effectively breaching confidentiality if your withdrawal would infer an obvious answer? Well, the point is you have to withdraw and not answer the question. So it's an impossible situation to second guess that, because what's the alternative? You stay on the case and don't give an answer. I mean, it's just a massive conundrum. So I think withdrawal is the only option in that instance. I think that was the only. Oh, there's one other substantive, quite long question, Susan.
Yeah, I think that's one's directed to the question Lachlan was answering. I'm not even sure I've quite worked out what the question is, as opposed to a posed scenario.
Yes, I think you go back to the principles of, if it's been a publicly stated position, then that matters, because of course it's already been put to the court. You need to take your client's explanation of why the instructions have changed again, get him commit to writing what the new instructions are. The fact that you have your own reservations as to whether the instructions are true or not, it isn't relevant. What matters is the client's explanation as to why these instructions have changed, and then you need to evaluate the position once you have that explanation. That would be my short answer.
Oh, perfect answer, Lachlan. Thank you very much. If we have no more questions and answers, we won't use this last minute. I'll simply use it to thank Matthew, Lachlan, and Martha for answering these ethical queries. I hope it's been of some use to you all.